So good afternoon and welcome, everyone. I hope everyone enjoyed the lunch, and welcome to the post-session special bonus section on the Supreme Court. I'm Colleen Connell, as many of you know. I'm the Executive Director of the ACLU of Illinois, and I'm delighted to be here and really dig a little bit deeper about the Supreme Court. We wanted to just alert everybody to the fact that we do have captions at today's event. To turn them on, please click the closed caption button at the bottom of your screen. Before I start, I just want to pick up on something that Oni Blair, the executive director of the ACLU of Texas, remarked. And she said, really, the courts are not, at least at the present time, our friends. And I think that that is really a good starting point for today's discussion, because it is inconceivable to me, not just as a lawyer, not just as the executive director of the ACLU of Illinois, but as an American who really cares about advocating for rights for all, that we not give up the fight in the courts. The courts in so many ways are the embodiment of the rule of law, and I think that we cannot withdraw from that forum. And so we are so very fortunate that we have two great panelists here today to discuss the court. I want to introduce you again to David Cole, who you saw during our virtual lunch. David is the National Legal Director for the ACLU and directs a legal program that includes approximately 1,000 state and federal lawsuits on a broad range of civil rights and civil liberties issues. So welcome, David, again. Thanks for joining us. And I also want to welcome Sufyan Sohel. Sufyan is the Deputy Director and General Counsel at CAIR-Chicago, which is Council of American Islamic Relations. And he's also an ACLU of Illinois board member. And personally, he is a longtime ally of the ACLU of Illinois, who I've had the great good fortune to work with over a number of years and on a number of really important issues. So welcome, Sufyan, and we're just really delighted you're here as well. And so I'm going to hand it over to the two of you to further enlighten us about what we should think about, what we should expect in the courts.
Thank you so much, Colleen. David, wonderful to see you again. Just a note to all of those who are with us today, welcome. We're glad you're here with us. And we invite you to submit questions during the conversation by adding them to the Q&A feature on the bottom of your screen. If you have any tech issues during the event, please message the host in the chat. So David, I know what's on most people's minds this week is a Supreme Court nomination. It's been all over the news, in our hearts. We may soon have our first Black woman U.S. Supreme Court Justice. Now, in my completely personal opinion, this nomination is definitely the right step towards having a court more representative of the American people. As a child of immigrants and from a community that is constantly experiencing hate, I resonate a lot with a lot of what was said from Judge Ketanji Brown Jackson, as well as from some of those senators who spoke on her behalf. It really touched me when Senator Booker talked about the challenges and indignities still faced by so many communities. Now, I was a political science major for a really hot second in college, but I still find these hearings and this entire process so fascinating. You know, you have different dichotomy from questions that Judge Jackson faced versus others who came before her and before the Senate Judiciary Committee in the recent past. We have bantering between the senators, high levels of emotion, the grace with which some candidates hold themselves and others don't, especially in the face of what I thought were inappropriate and very misleading questions at times. And I've been wondering, as a lawyer and activist, is this the process that was envisioned by our founding fathers when giving Congress this advice and consent to the president's nominations of federal judges? David, I would love your thoughts on this nomination and confirmation process, and whether you believe this is still the best way for us to assess whether these candidates will be good Supreme Court justices.
Well, I don't know if it was ever the best way. It's been something of a charade, for a very long time. I think for a significant part of our history, it was a fairly pro forma process. But the fact that until very recently, you had to get 60 votes because of the filibuster, I think puts some checks on the process. The elimination of the filibuster so that, whoever's the majority party, they're going to get their person through, almost surely. Sort of, I think, sadly, contributes to the kind of degradation of the process that we've seen. Because, it's a done deal. She is going to be confirmed. She should be confirmed. But as a result, what you have are senators basically using this for, a political show. And, I think you could make a strong argument that, for example, the British system for selecting judges, which has panels of experts that are bipartisan, that pick a slate of folks and then offer them up to the prime minister, and then the prime minister chooses from that slate, is one that is better suited to picking better justices. That's not the system, the framers chose. They chose to make it a political system. And once you make it a political system, sort of all bets are off. And I think what we've seen is, just further evidence of the degradation of our political discourse in this country, and the polarization in this country, on display in a really sort of embarrassing way this past week.
Thank you. And I love how you said embarrassing way, because a lot of times when we see these things, it makes me cringe so much. It's the spectacle that we have for the sound bites on all sides, right? And are they really interested in this process, or are they just trying to vie themselves up for something else? And it's becomes disheartening. To pivot slightly, in the keynote, you talked about how the Supreme Court is a challenge right now. But what I loved a lot was you also talked about how hopeful you were about what's coming next. I would love for you to share more with us why the Supreme Court remains critical to advancing and protecting our rights and liberties.
So look, I'm not going to, paint it with rose-colored glasses. You've got a 6-3 conservative court, and that means, I spent a lot of my time drafting briefs for the Supreme Court on behalf of the ACLU. And, when you're writing to a 6-3 conservative court, it can be a challenge. The sort of room for victory has definitely gotten a lot narrower, and that is disturbing. I will say, sort of as a matter of context, that we've had a conservative majority court, a Republican appointed majority court, since about 1970. So it's for half a century. So it's not new. We've been fighting in this kind of a setting for a very long time, in part because of the filibuster. That Republican-dominated court for 50 years was not nowhere near as conservative as this Republican-dominated court is today, because you had to appeal to both parties to get someone on the court, and so you had more folks who were more moderate, who might be more open to argument, and that seems less the case today. So what do we do in response to that? We keep fighting. Right, we keep fighting. What else can we do but to keep fighting? And I think there's a number of ways to think about it. One is, it would be a whole heck of a lot worse if we weren't in there fighting. You need to have our side, the side that values rights and liberties, articulated strongly in every case, to make it as hard as possible for the court to do bad things, and to make it as likely as possible that the court will do good things. And so we have to keep fighting. We have no choice. We can look for alternative fora, state courts, state legislatures in some instances, even Congress maybe on some issues, depending on how Congress develops. But the reality is that for some core sets of issues, there's nowhere to go but the federal courts. If you're talking about immigration, for example, if you are challenging discrimination in voting practices, you're going to be in federal court, and so we're still heavily reliant on federal court, but we can also win in federal court. At the end of the Trump administration, Trump had appointed 25% of the federal judiciary. That's a big number, but at that point in time, 40% of the federal judiciary were Obama appointees. And that was before Biden started appointing, a lot of people with a lot of credibility in terms of civil rights and civil liberties to the court. So there are lots of judges out there who have a real affinity for civil rights and civil liberties. Some of them are those appointed by Trump. Many of them are those appointed by Obama and Biden. And many cases never get to the Supreme Court. The vast majority of the cases we do never get to the Supreme Court. We win in the district court, and then there's a settlement, or we win in the Court of Appeals and the court doesn't take the case. So we focus a lot on the Supreme Court, and it is a very powerful institution, but we have to keep in mind that there are that not all federal cases go to the Supreme Court.
And thank you for sharing that. And I'm going to talk about some of these and ask you about some of these cases specifically. Just recently, the ACLU filed on behalf of 3 Muslim U.S. citizens who claimed that they were asked inappropriate religious questions by government officials upon entering the country from traveling abroad. This is something I personally have been invested in and worked on over the last 5-6 years with the travel ban work. And what I've noticed is this huge increase in fear and uncertainty from members of my community and so many others. The sense of we don't belong in this country, government is attacking us, they don't want us here, and they is the broader sense of an American community. They don't know who's supportive of them and who's not, and reach out to organizations like us for that support and assistance. A few weeks ago, the Supreme Court recently ruled on another case, FBI v. Fazaga, which involves surveillance conducted by the FBI in the Muslim community in the years following 9/11. Can you share a little bit, please, about what the case was about and break down the court's ruling?
Sure. This is a longstanding case that we brought in LA, challenging a practice of the FBI in infiltrating the Muslim community in this LA area, paying an informant to attend mosques, to report on the people who attend the mosques, to report on the ones who are the most religious, and to tape conversations in the mosque. And he, at some point, he sort of grew disillusioned with the FBI and went public with what he was doing. And so we brought a lawsuit on behalf of a number of the individuals who had been the subject of this surveillance, arguing that it violates the First Amendment free exercise clause, the religion clause, to target a group of people because of their religious practices, to focus on those who are the most devout, and to go into, without warrants, to go into their mosques and tape conversations in those mosques. And the government's response was, it's a state secret. The program is a state secret, and therefore you can't sue us. Even if we violated your rights, even if it's clearly unconstitutional to investigate on the basis of religion, it's a state secret, and therefore you can't. The case cannot go forward. We prevailed in the Ninth Circuit on an argument that a provision of the Foreign Intelligence Surveillance Act gave us a route to go forward on these claims, notwithstanding the claim of state secrets. And that's what the Supreme Court took up. So it was a case that pitted free exercise rights on the one hand against secrecy on the other. This is a court that's generally very sympathetic to free exercise rights. It just yesterday ruled that Texas had to allow a person on death row to have a minister in and lay hands on and pray with the defendant as he was being executed, 8-1. And yet, in this case, the court ruled against us and said, no, the Foreign Intelligence Surveillance Act does not provide a way for us to litigate these claims, notwithstanding the claim of state secrets. The silver lining is that the court did not adopt the government's broader position, which is that the case should be dismissed altogether, and instead sent it back to the lower courts, where we have taken the position from the get-go that we can litigate this case without access to any state secrets. We don't need the secrets. We have testimony from the informant. We have testimony from the individuals who were surveilled. We can make the case without that. And so we're back in the lower courts seeking to make that case. So it was a disappointing loss before the Supreme Court on a statutory question regarding the Foreign Intelligence Surveillance Act. But the good news is that the case continues.
That's great. And thank you so much for your work. Not a week goes by that we, just in Chicago, don't receive a phone call from a member of the community or a mosque who has a similar sort of engagement. Anecdote for you, in California, several years ago, there was one mosque that actually called the FBI on the informant that they had sent to the mosque, because they're like, who is this guy? What are these questions that he's asking us? We don't trust him. And, it's creating, again, this level of fear and uncertainty and not being accepted as part of the American diaspora that we're constantly trying to push back against.
Yeah, and we've been, as I'm sure many folks on this call know, we've been working with you, with CAIR, on this issue for a very long time.
Thank you. Another question, an issue that a lot of our attendees have been curious about is abortion rights. Recently, the Texas Supreme Court ruled that the Whole Woman's Health versus Jackson couldn't proceed against the Texas Medical Board and other similar state licensing officials. We're seeing that these rights continue to be challenged across our court systems. What do you expect the court to do on abortion rights, especially the challenge to Roe raised by these Mississippi cases?
Well, this is the biggest, by far the biggest case in the court this term, and that is the Mississippi case, where the state has asked the court to overturn Roe altogether. And the argument in that case did not go well in terms of tea leaves. It looked like 5 justices were ready to overturn Roe altogether. It looked like Chief Justice Roberts was suggesting that the court only affirm the 15-week ban that is at issue in the Mississippi case, which would be a significant rollback from Roe and Casey, which protects the right to abortion up to viability, which is about 23 weeks. It would be cutting that back to 15 weeks. But that's, from the argument, that's the best we're going to get. A rollback of protection of women's right to control their bodies to the first 15 weeks of pregnancy, which would be disturbing enough. But if they overturn Roe altogether, groundbreaking, really. And the only thing I can say there is, if they do either, I think there's a real possibility that it will dramatically change the politics of abortion in this country. To some degree, the fact that we have had a constitutional protection, a backstop for abortion for 50 years, has let the side that favors the reproductive autonomy of women sit back a little bit and not fight. I mean, of course, we're fighting. The ACLU is fighting. Planned Parenthood is fighting. the Center for Reproductive Rights is fighting, but the American public, doesn't have to fight that much because laws get enacted that restrict the right to abortion and then they get struck down. Our Reproductive Freedom Project probably has the best won-lost record of any project within the ACLU because so many unconstitutional laws get enacted and we get them struck down usually the day they go into effect. And so that meant that our side was kind of sitting back to some degree, and the other side, the side that wants to restrict women's rights, was very active, very engaged. I think what you're going to see is incredible engagement on the side that wants to ensure that women have this right. And that may well change politics in very significant ways. But that response will determine where abortion rights go long term. I look at a country like Ireland, a deeply, deeply Catholic country, and they have come to a kind of resolution on abortion that recognizes the right of women to have abortions. If they can reach that resolution, I think we can too at some point, but only if those of us who care deeply about the freedom of women to control their bodies, to ensure to choose when to have a child, when to have a family, to be able to pursue a career and a family and the like, stand up and fight back. But if we do, I think we can ensure that women have this right.
Thank you so much. I think what you're saying is spot on about how we have a collective responsibility to fight and can't leave it solely to the court systems. And I think that's a note from this conversation that I hope hits hard for everybody and they take it to heart. My next question, as we're closing up on time, is about LGBTQ rights. The Supreme Court recently took a case from Colorado about using religion to discriminate on those rights. Could you please share a little bit about the facts of that case? And are you concerned about where the court will rule?
To answer the second question first, yes, but that's probably, you could ask me that with respect to almost any question about the court these days, and I would say yes. The case that the court has taken up, it's called 303 Creative, and it's essentially a kind of rerun of Masterpiece Cake Shop, which is a case we handled and I argued in the Supreme Court a few years ago on behalf of the baker that did not want to make a cake for a gay couple to celebrate their wedding because he opposed same-sex marriage. And this is a kind of made-up case. It's brought by the Alliance Defending Freedom, which is the organization that represented Masterpiece Cake Shop and that is engaged in almost all of the cases we're involved in on LGBT rights. Their anti-LGBT rights. We're seeking equality and dignity for all, regardless of your sexual orientation or gender identity. And what they did was they've come forward with a website designer who says that she wants to go into business to create websites for weddings, but she objects to same-sex weddings, and so she doesn't want to do it for same-sex weddings, and this law would require her to serve same-sex couples on the same basis as opposite-sex couples, and therefore infringes on her First Amendment free exercise and free speech rights. And the court took that case up. My own view as to how the case should be resolved. The proper question is, what is the government regulating when it passes a public accommodations civil rights law? Is it regulating speech? Is it regulating religion? If it is, then it ought to be subjected to heightened scrutiny and probably ought to fall. But if it's not, if it instead is ensuring that all businesses, regardless of whether they're religious, regardless of whether they're expressive, treat all customers equally without discriminating on the basis of race, religion, sexual orientation, gender identity, and the like. And that interest in non-discrimination has nothing to do with whether the business happens to be communicative or not, then the case ought to be a fairly straightforward one. And this is not new. This question arose in the 60s when the Civil Rights Acts were enacted and when restaurants objected to to being integrated. And they said, it violates our First Amendment right not to associate with Black people, or it violates my religious conviction, Bob Jones University, my religious conviction that Black and white people should not be in relationships together. And our First Amendment rights should trump the non-discrimination principle enacted in the civil rights statutes. And the court consistently rejected those arguments, saying these are not speech cases, these are not religion cases, these are discrimination cases. If the government is regulating discrimination, you don't get an out because you claim a First Amendment exemption. If the government is targeting you because of what you say or because of your religion, then you get heightened First Amendment scrutiny. I think that's the way the case ought to be resolved. Whether it will be resolved that way, only time will tell. I will say this: Masterpiece Cake Shop, the court took that case up to rule for the baker on that ground. It ultimately did not, and it found a very narrow way to rule for the baker. Last term, we had a case called Fulton versus City of Philadelphia involving Catholic Social Services, which wanted to get money from the city to certify foster care families as suitable for foster care children, and did not want to certify any same-sex family, no matter how well suited it was otherwise. And they claimed they had a First Amendment right to do this, even though the city had a non-discrimination clause in its contract and in its charter. And the court again took that case up and ultimately resolved it on a very narrow basis without saying there is a First Amendment right to discriminate. So they've twice taken these cases up in situations where it looked like they were going to announce a First Amendment right to discriminate, and they blinked both times. This is the third. We'll see.
We'll see. Thank you. We have a number of questions from the attendees and participants, and I'm going to try to lump them together. We have about 5 minutes left, so brevity would be key, I think, in trying to get some of these. The first set is on court expansion. What are your thoughts, pros, cons, in increasing the number of Supreme Court justices?
I'm against it, and the ACLU is against it. It will only further politicize the court. If the Democrats add 3 this time, then the Republicans will add 3 the next time. So I don't think that's the best sort of reform to proceed with.
Wonderful, thank you. We're seeing emerging technologies. So Meta is all over everything these days. Been talking a lot about policy and ethics. What issues with regards to emerging technology do you anticipate being heard by the Supreme Court?
Oh my God! What issues won't be heard by the Supreme Court? One of our areas of prioritization for the last 10 years or so has been dealing with the consequences of big data and the data revolution and social media for our constitutional rights. And they range from privacy rights, because, oh my God, our private lives are out there, and to what extent can the government use these technologies to surveil us in ways that they couldn't before? It includes speech rights. How should speech rights interact with the social media platforms and calls to bring to regulate disinformation and misinformation on social media. It calls for we talk about data discrimination, AI and algorithms which are used to make decisions about hiring, about bail, about child protection, often built in discriminatory practices that we are seeking to kind of reveal, challenge, and extirpate. So the Constitution is a constantly evolving document, and it has to evolve because the world is a constantly evolving world, and that has been a central part of our program going forward, because it has to be.
Oh, definitely. Last question I have is kind of long. The Illinois legislature passed a bill several years ago to protect immigrants from profiling and to restrict local law enforcement from cooperating with federal immigration authorities. Do you see a future for other such protective state laws and state court enforcements?
Absolutely, and we have had some success in a number of states along these lines. On that issue in particular, the federal government can enforce federal immigration laws, and they don't need state governments to do so. And many state and local police chiefs will tell you that it interferes with their ability to do their job in protecting the community if people are afraid to go to them because they feel that if they go to them, say, as a witness or as a complainant, they might face deportation or face some member of their family facing deportation. So a strict sort of divide between state and local law enforcement, doing the bread and butter criminal justice kind of issues that we need them to do, and federal immigration authorities doing immigration enforcement makes a lot of sense. And many states recognize that, and we've been fairly successful in obtaining that protection, which is real, lived on the ground protection for many immigrants and serves the interests of everybody because it makes the job of state and local police departments less complicated.
Thank you, David. Before we leave, any last words, David, for our attendees today?
No, I guess one. I saw the comment that the court is already politicized. To be sure, I don't want to deny that, but I want to say this: we don't want to contribute to the further politicization of the court. We want to, the last thing you want is a court that's where everyone says, of course it's politicized, and it's okay that it's politicized. Because a politicized court, we will lose every case in. A court that strives for the ideal of justice above politics is a court in which we can sometimes prevail. It's a court in which a conservative majority court recognizes marriage equality or extends Title VII's non-discrimination protection to sexual orientation and gender identity, which it did just 2 terms ago in the Bostock case, which the ACLU handled, or protects dreamers, as the court did 3 years ago with John Roberts joining the liberals, or strikes down the president's attempt to skew the census, which the court did in our census case three terms ago. So we have to stand up for and defend the principle of a neutral Supreme Court committed to the Constitution and not a politicized body. At the same time, we have to use our political power and our political wherewithal to fight in every forum, not just in the federal courts, not just in the state courts, not just in the state and federal legislatures, but in your town councils and on your school boards for the principles that we believe in at the ACLU. That has been what the ACLU has done for over 100 years. And I'm just so grateful for all the support that the people on this call have provided to that collective endeavor, because that's where liberty lies. It lies in our efforts to stand up for the principles that we believe in.
Thank you so much, David, and especially to you, Colleen, and the entire ACLU teams nationwide for really living this mantra of working towards protecting our civil rights and liberties. We're so grateful for your work, and grateful for all of you who joined us today for the luncheon and this bonus session. Please stay tuned for more information about the ACLU of Illinois, our work, and ways to take action over email and social media. I hope you all have a wonderful weekend, and thank you again.